Mr. Goy.
Good morning, Chief Justice Marshall. Good morning, Your Honors.
Good morning.
My name is Randy Joy. I represent Eric Boyarsky in this matter. Elizabeth Billwitz, who was on the brief, is sitting here with me. I'd like to start my argument with the argument that we raised in the supplemental brief, the due process argument with respect to the jail calls, I think.
Well, why hasn't that been waived? And I think the Commonwealth makes a pretty good argument that there's nothing in the record that we would need, or there isn't enough in the record as to policy, regulations, et cetera, because you weren't going that way either at trial or even in your original brief.
Right. I think it wasn't raised at the trial level, but I think there is enough in the record that you have in front of the court to make the decision in this case, because number one, what you have in the record is that there was this jail form that Boyarsky signed, and it basically said in the jail form that the calls would be monitored and recorded and that they could be used for any lawful purpose. So I think that's enough right there to look at and examine Boyarsky's subjective expectation of privacy. Number two, and I think this...
You say that's enough to show that this is a definite policy that...
Yeah, I think that's essentially the policy there that he signed and that he knew about, so that there's enough right there in that form for you...
Well, tell me again why that isn't enough to permit...
It is enough.
It is enough.
Tell you again why it is enough?
Well, what is wrong then?
And what's wrong substantively with the policy?
Yes.
I'm not sure I understand the question.
You're crossing on the word "what is enough." It's because you don't agree on enough to do what.
Well, to determine what Justice Cowan is asking, we waived it because we didn't raise it below, and so if we didn't raise it...
I was asking a different question.
Yeah.
In view of that, what he signed, what was wrong with the fact that they taped the phone calls or recorded them or whatever?
Right. And
nothing.
It's the use
no,
of
there's
them.
nothing. There's nothing wrong with. I'm certainly not arguing that the jail did anything wrong by recording the phone calls.
Okay, so
That's
therefore
not the
they could
argument.
use them in court.
Well, I wouldn't go that far. I wouldn't go right to that point, because what happened here, and I think that's the other point I wanted to address with Justice Cowan.
Our argument is that the jail authority shouldn't have turned them over to the district attorney's office, the state police, to just look at them randomly.
Well,
without
and more than that is what you have here is the evidence was that the state police went to the jail, I think, on 3 or 4 occasions, separate occasions, and picked up discs, CD discs of the calls. So I think the inference there is pretty clear that that was a wholesale dissemination of the calls. This isn't a situation where I think the jail was listening to certain calls that Boyarsky made, that they heard something on the calls that sounded incriminating, and that they just turned it over to the police.
Is this practice widespread as far as you know?
I certainly think it is, Your Honor. I think it's happening. I know in my murder cases that I have, I think it's happened in almost every case now. What you have is the Commonwealth just getting all the calls that the person made.
Is there any case law that says it's wrong to do that?
No.
Mr. Joyette?
Well, there's no appellate case law that I'm aware of that's directly on point there. But there's the decision that Judge Riley authored in the district court that is right on point with our court.
Superior Court? Do you mean Superior Court?
District.
In Superior Court, yes, that's what I meant, Superior Court, the Dubose decision. And I think the Cohen decision, which is a Second Circuit decision, is also, it's not exactly on point. It's not the same factual situation, but I think that's also a very strong argument that this is a due process violation for the jail to just turn over the entire calls. That's what the district attorney or the police are looking for. They want all the calls.
But isn't Cohen different, Mr. Joya, because there was no evidence that the recording of the of the call, well, here there's no evidence that the recording of the calls was prompted by the prosecution. The recording, that's a distinction between them.
Well, that's the distinction that the Commonwealth makes. I'm not sure that's a good distinction, because what I would say to that, Your Honor, is that I'm not concerned with the recording of the calls.
Could I just stop you right there? I thought in your brief, your first brief, that you were arguing that the recording somehow violated the wiretap statute. Did I miss that? That because yes, there was the notice, but it wasn't really consent.
Well, no, the argument that we were making was the dissemination.
It was always disseminated.
Yes.
Okay.
So, by the way, do they record calls between an inmate and a lawyer?
No.
How do they know? They turn off once they hear. Is there somebody actually listening then to all the calls? How do they
But
know?
they just don't
How do
disseminate
they know?
that.
No, I don't think they even make I think what it has to do, Your Honor, and I'm not sure that's in the record here, but
No,
from my own personal knowledge of it, there's some kind of a procedure that they can tell if it's an attorney call, and they just don't record those attorney calls. There's a
They
PIN
don't
number.
record them at all?
Pardon?
They
They
do.
don't record them at all. That's my understanding now, that they don't do that at all, because there's a PIN number that the inmate can put in.
Okay, that's
And
how
that
they do it. I just
indicates
didn't
that that's an
understand how
attorney
that was
call,
done.
and if it corresponds with the PIN number.
Okay, but of course, these calls could just, well, all right.
But I wanted to address that point about the Cohen, that in Cohen, the argument is that in Cohen, the U.S. attorney told the sheriff, go in there and search because we want to see if we can find any evidence relating to our crime. And the argument that the Commonwealth makes, well, in our case, the district attorney didn't initiate that. It's the sheriff who initiated it by making the recordings. And I agree with that. The sheriff
And
made
we've
the
already
recordings.
upheld that, and I think the Korea case that Justice, no, the Caccio case that Justice Graney wrote, that this is practice
That's
is
okay. I have
for-
no quarrel
Okay,
with
so
the
then
cut-
he's lost his expectation of privacy.
No, what I'm saying is that in the Cohen case, the difference is that here, the recording is okay. It's the monitoring
Well, what's
of
wrong
the
with
Right,
call.
he's lost his
That's the
expectation.
problem.
He's lost his expectation. He doesn't have any reasonable expectation of privacy because he's told 10 times over that these are all being recorded. I mean, he's given written notice, and he's told
Absolutely.
on every, so he has no expectation of privacy.
But
in them.
he's not told that these calls are going to be used and given wholesale to the prosecution so that the
They could-
prosecution has the right to look at and scrutinize every single call.
The prosecution, you mean the state police?
Yes.
They weren't given to the DA.
Yeah, they are.
No. Well, they eventually are given
Well,
to
they're
the D-
filtered by the state police.
Yeah,
But
but
the state
I don't see
police
any
is-
difference
yeah,
between that and the state police
it's
who
a-
are investigating the case.
Right.
It's
It's
like
part of the
if I use-
prosecution team.
Yeah, but
Yeah.
they're told in advance that they can be used for, or given away, or used for any legitimate purpose, any lawful purpose. And doesn't a sheriff have a legitimate interest in ensuring that people who are in the jail are not conducting business, criminal business out from within the jail?
Oh, yeah, absolutely. I agree with that. If there's a legitimate penological interest, the sheriff has that. I'm not saying that the sheriff can't listen and monitor the calls for that particular reason. And let's assume that the sheriff is monitoring the calls for a legitimate penological reason. They want to make sure that nobody's planning an escape.
Yeah, but wouldn't the state police be necessary to help him with that, the sheriff? Because they got a much broader knowledge of what's being investigated, what kind of codes might being used to smuggle
But that's not what
drugs
they're
in the
doing.
jail.
I mean, that's not, maybe, if the sheriff said, we need some, why doesn't the sheriff hire somebody from the state police then to do that? But they're
The
not.
question is not,
They are,
why should he not do something? The question is it okay to have the state police do it for him?
But what you're talking about is the state police assigned to this case who are listening purely for evidentiary reasons related to this case.
that's exactly what they're doing. They're taking the calls, what I call it bulk dissemination of the calls.
Well,
State police-
if there were if we were to require going forward an additional warning on these warnings at the beginning of the conversations that these tapes may be used for any lawful purpose, including prosecuting you in the case for which you are incarcerated or any other case, I assume that you would then have no problem. There would be an
well,
adequate warning.
Actually, that's what's taken place now. And I know in Middlesex County they've changed the warning. But I would still have a problem with it. I would still have a problem with due process under fundamental fairness issue of due process.
Can this man be so naive when he signs a form that they're going to record the call to expect that they're not going to turn over when he's being charged with murder, that they're not going to turn that over to the authorities to see if some proof of the murder might exist in these calls?
But, Your Honor, my response to that is, maybe you're right. Maybe there's a lot of naive people there in the jails, but the people who are in jail awaiting trial, especially on the murder cases, this is really their only means of communicating with their, well, I'm not saying their only means. They can get visits.
And is there mail open?
And there's mail.
Yeah.
But this is the primary means.
Is the mail opened?
The mail is opened. The mail is opened and read.
But the visits aren't overheard. There's private conversations during the visits. They're
Not in every
recorded.
jail.
Well, see, we don't have
And you
a
don't have
record
that in the
of
record. You don't have that in the record, too, and that's just my
I
own
take it,
personal
Mr.
knowledge.
Goyer, your point goes something like this. This is the most important means of communications.
Yes.
Many of these people may not be literate.
Right.
We may not like to acknowledge that, but they, in fact, letter writing is not an effective means of communication. Many of them don't have visitors, or visits are very difficult. And so they have conversations with their families and their friends during the, not in order to carry out any further criminal activity, but simply to talk. During the course, I take it this is your argument, during the course of which they may say something which a good defense attorney, prosecutor, or anybody else listening to can use as evidence against them.
Absolutely,
Isn't that
Judge.
essentially your due process argument?
That's a very succinct way of putting it.
Yeah,
And the other
but
thing that I want...
Are you saying if one of these calls said, the defendant said to someone on the telephone, look, we got to get rid of this witness against me in my upcoming murder trial. I'm not saying that occurred here, but if the defendant said that, they cannot turn that over to the state police?
No, I'm not saying that. I'm not saying that, and I want to make that clear. Let's say, you're saying, Justice Greene, is that let's say the sheriff was legitimately listening to the calls, which they do. They pick random calls to listen to.
They pick random calls and they hear something.
And they heard something like that. There's no question I think they can turn that over. That's like the plain view doctrine. If they're there and they're listening to these calls legitimately...
There's a lot of other stuff that's private.
But what I'm saying is, as Justice Marshall has said, a lot of times what they're doing is they're just talking to family. Family's calling up, they're asking, well, how's the case going? What does your lawyer say about it? Do you think you're going to get out? What about this evidence we're reading about in the newspaper? And the person just, even though they know that the calls are being recorded, you're having a conversation with your family or your friends, you're inevitably going to be talking about these issues.
Have you listened
and the prosecution knows about it.
Have you listened to all these phone calls?
Not in the Boyarsky case, no.
Right. So therefore, you cannot tell us with specificity there's any type of personal call that you are now talking about that has been intruded upon in these tapes.
No, I can't tell you that in this case because I know just what they used in this case, in this particular case. But I think that's...
Which is incriminatory.
It's incriminatory.
Yes.
But that's because the state police took everything and listened to everything and picked and chose. They scrutinized everything and they picked and chose.
Well, if a defendant is calling a relative and says, geez, I hope they don't go to the garage where I work and look under the such and such place because that's where the murder weapon is.
Yeah.
I mean, can the police not use that?
Of course they can.
No, well, how do they
No,
get
your answer is no.
Well, no, how do they get that?
Well, the sheriff gave it to him.
No, but what you're saying is if the sheriff in his random listening hears that, he can turn it over.
He can turn it over in his random
But what
listening.
the sheriff can't do is give every tape of Mr. Boyarsky's from April 1 to October 1 wholesale to the state
without
police
a legitimate reason.
to listen
Then
to.
imposing a huge burden on the sheriff. The sheriff is going to listen, or the state police and the DA's office will want the sheriff to listen to every conversation of every inmate who's coming up for a major case. And
I don't think the sheriffs are going to do that. I don't
that's
think
right. They're not going to do that.
The sheriffs don't have the knowledge that the state police have.
And they're
that
not
are
gonna-
investigating these murders. So
But you're saying it would be all right if the sheriff did it. You're making a distinction that the
As long as
wholesale
the
turn
sheriff is
over.
doing it for a legitimate penological purpose, they certainly have that. And to answer Justice Spina's question, Your Honor, It's the same thing if they did an illegal search and they
Mr.
found the
Goyer,
murder weapon, and am I saying because they did an illegal search they couldn't use the murder weapon? Yeah.
Mr. Goyer, let me ask you this question. From your point of view, if the police have reason to believe that that the person who is incarcerated, the alleged defendant, was working in concert with somebody who hasn't been incarcerated, can the police ask the sheriff for those telephone calls?
In other words, what you're saying, Judge, is if they have some specific reason that there are calls that may contain evidence, how do they get to those? I think that's a different question.
I know it's different, and I'm
I
just trying
think
to push you to see.
Yes. I think if they had a specific reason, and they had an articulable reason
to think that he was,
to think that
for
he,
example, continuing to conspire to cover up.
right, or if he had made, let's say, a statement to a friend that was inconsistent with the statement that the defendant had given in a recorded statement to the police. Let's say the police, this was in the Fitzpatrick decision that the Commonwealth gave over to you at the end, where the defendant made a statement on the phone that was inconsistent with another statement he had made before he was incarcerated.
How is the sheriff ever going to know that? You see?
No, the sheriff didn't know that,
No, but
the witness told the state police,
I know,
and then they got
but
that.
that's
and
why the sheriff's listening is a very impractical resolution. The only person who would know whether anything of value to the case is on the tape is the state police or the DA who's working on that particular case.
If they know, it's okay, but it's this wholesale dissemination of every single call that
So
the
you're
person
saying-
who's
you're saying
incarcerated makes.
You're saying in the Fitzgerald case,
Fitzpatrick.
Fitzpatrick, the state police, he made a statement to them which they believed was inconsistent with the prior statement that he had made.
In Fitzpatrick, he made a statement to a friend of his over the phone, and the friend spoke to the police
I
and
see.
said, you know, Fitzpatrick told me something on the phone that was different than what he told me when he was out.
If they've got probable cause,
Yeah,
it's
they-
okay, but if
right.
they don't.
See, I think
they
in
can't
that
do a random
situation,
search,
that's
you can't
different.
do
But
They
then
can
they
go
have
get
to.
that.
Then this is the same thing. They have to know what's in the box before they can get into the box.
And sometimes they can, just like in a, if it was a real box, like a house or something like that, sometimes they do have probable cause to go into the house and get
Is
something.
this issue of any significance? He confessed to the murder. Blood was found on his shoe.
No, you're raising the harmless error issue.
This was objected to.
The phone calls?
The quote, wholesale, unquote, review by the
No,
state.
it wasn't raised.
So it's not.
So it wasn't raised. So is there going to be a substantial likelihood of a real problem here when he confessed, blood was found on his shoe that matched the victim's DNA to beyond a scientific certainty, et cetera?
No, well, I'm not sure there's et cetera, but that's, I mean, that's
a pretty good
pretty good right there.
stuff. Yeah.
But I want to
1 in
talk,
704.7 quadrillion.
it's a lot of zeros.
Yes, it is.
But you want to talk about the panic disorder? do you?
No, I do want to talk about this harmless error. I think that's a good,
No, it's a likelihood argument because the
Substantial
phone calls were.
right, substantial likelihood of miscarriage of justice, and I want to talk about that. And what you had here is that the key piece of evidence in the case for the Commonwealth was the unrecorded confession that the defendant made. And that was the key challenge that the defense made, that this was an involuntary confession, it was unrecorded, he was having a panic attack.
Motion to suppress made.
Motion to suppress made, all
Heard,
of that.
denied.
Heard, denied. The telephone calls that the defendant made were used by the prosecutor to corroborate the voluntariness of that confession. So they played a very, very important part in the Commonwealth's case. And there was one part, and I think it's ironic that they chose not to record the interrogation.
Wait,
but
how do phone calls go to the voluntariness of the confession? They would go to the substance of the confession to show that
they did that also.
Yeah, but how do they go to the issue of voluntariness? I mean, somebody hypothesized the police could have beaten the guy. So how do the phone calls in which he corroborates what he said go to the voluntariness?
That's a good question, because the prosecutor argued, listen to these phone calls. Listen to the way Boyarsky's speaking on the phone calls. He's an intelligent guy.
He's not subject to panic attacks.
He is talking legalese about motions to suppress, et cetera, et cetera. And then the other thing he did is he picked up a photograph of Boyarsky that was taken because after Boyarsky made this confession, they arrested him and they took a full-length picture of him. And he picked up the photograph and he showed the jury, he said, does this look like a guy in the middle of the throes of a panic attack?
Well, why not? That's perfectly good evidence.
What's wrong with that?
The police are always
But
accused
here
of
they
it, so
are
they take
using
photographs.
the photograph that they chose to take a picture of him using the photograph, but they chose not to record his statements, and they're using the recorded phone calls because they're incriminating. Ironically, they didn't choose to record the interrogation, which they could have done. And I think that's unfair.
Did the judge give the instruction that we've indicated
Yes, he
should
did.
be given?
He gave the
DG
DG Batista instruction as the court. I think one of my arguments that I made here is it should have been a little bit more in this case because of what happened during the cross-examination in the DG Batista.
But he did give precisely
what the court said you should give. The judge did give that portion of it, no question about it. We were asking for a little bit more than that, but my argument would be that the phone calls were very, very important to the prosecution. They bolstered the case, and the whole argument about the confession was that it was involuntary and essentially a false confession made by somebody who was in the midst of a panic attack.
Thank you, Mr. Guy.
Thank you, Your Honor.
Good morning, Ms. Lazar-Moore.
Good morning. Ellen Lazar-Moore for the Commonwealth. The court should not address the defendant's claim that the sharing of his recorded telephone calls violated his constitutional rights. Through the trial court, into this court, in his opening brief and his reply brief, the defendant failed to raise this claim. He raised it for the first time in a supplemental brief filed after the case was first scheduled for argument on the basis of an isolated Superior Court decision. For this reason, the claim is not only waived, but there's an inadequate record to address it. There is no record of whether the jail had a policy governing if or when it shared recordings, whether the defendant was aware of any such policy if it existed, how the police or the DA obtained the defendant's calls, and contrary to what the defendant is saying today, there is no indication anywhere that the police went and wholesale got CDs of all of the defendant's calls. For all we know, the sheriff was listening and did hear something
So you're saying that
incriminating.
this needs to be raised by a motion for new trial?
If at all, it should be raised by a motion for new trial.
Point out all of these defects in your brief.
I do.
Yeah.
I do.
And I take it that if we look at it under the substantial likelihood, you would say that there's overwhelming evidence.
I would say that if the court does address the claim, it should absolutely be denied, where the limited record that we do have absolutely shows that the defendant did not have an objectively reasonable, subjective expectation of privacy in these
No,
knowingly
I don't mean
recorded
specifically
calls.
it's least.
Guilt.
I'm sorry, what?
We would have to review everything in any event under the 33E review, and you're saying that without specifically addressing the claim, you would say there's no substantial likelihood of a miscarriage of justice.
I would say that, although I would also say that even under 33E, the court is obligated to address things that are apparent from the record, not obligated to address things about which there is no record, because the defendant neglected his duty to make one.
But you would say that the evidence of guilt is pretty close to overwhelming.
I would say
We
that.
got a confession. We got, of course, this DNA.
We have a confession. We have the defendant's admission that he was home on the day of the killing. He's seen that the next day with scrapes on his hands. He is found with the victim's blood on his shoe, even though he claimed to have never been in her apartment or any other apartment in the building. He lives in the building on the floor beneath where she lived, and a partial footprint that matches the shoe that he was wearing on the day of the killing is found on a clipboard on the floor next to her body. So I would say that the evidence is overwhelming.
What I should know this, but I don't. Has there been a motion for new trial?
No, there hasn't. This is the direct appeal.
If we agreed with you and said it wasn't raised here, and there's no substantial likelihood of a miscarriage of justice, however we go on to address this for the future, would you have any problem with that? Because this obviously is an issue that's coming up.
Well, my problem with it is only that I don't believe this is the case in which to address it. If the problem is as widespread as the defendant claims it is, then clearly there will be a case in which there is a proper record, it has been briefed, a trial judge has had the opportunity to address it in the first instance, to have an evidentiary hearing, to make all the findings that are appropriate before a case comes before this court.
Yeah, you may have a point, because to spread a lot of dicta on it could, without a really firm basis in the facts, particularly the penological interests that are involved in the relationship between sheriffs and the state police, could create an awful lot of chaos in the law enforcement and imprisonment area.
And it's not warranted in a case where the claim wasn't raised, we don't have any evidence to support it, and we simply don't know. And this is also the type of claim which the result may be different on a case-by-case basis. If it is based in large part on that particular jail's policy, which the Superior Court decision in Dubose was primarily based on the contents of the jail's policy, well, each jail may have a different policy. And there may be differences in whether those particular defendants knew of the policy in each case in order to have where Judge Riley found that Mr. Dubose had a residual reasonable expectation of privacy. There are a lot of specific factors that might arise in each individual case that will change the result.
Do you happen to know whether the Dubose case decided by Judge Riley has been appealed by the Commonwealth?
I don't believe that it has, and I don't believe that they intend to appeal it. It was quite a while ago already. I will say that if the court does choose to address this, despite the waiver and the inadequate record, that on the evidence that we do have, that the claim should be rejected. Because the evidence we do have shows that there was no objectively reasonable subjective expectation of privacy. We do know that when the defendant filled out a form applying for a number allowing him to use the telephone, he was warned in writing that his calls would be monitored and recorded and that the calls could be used for any lawful purpose. That sheet that the defendant signed is in the record in the defendant's appendix at page 24. There was also evidence before the judge at the voir dire before the calls were admitted that at the start of every call the defendant made, he and the recipient of the call were warned by a recording that they would be monitored and recorded. So there is no question that the defendant knew he was being recorded, was told the recordings could be used for any lawful purpose, and there is no indication that he did anything to manifest any sort of a subjective expectation of privacy. And even if he had, it would not be objectively reasonable in these circumstances. He's making calls from jail where he's held on charges of first-degree murder. He is told that he is being monitored and recorded and that the calls can be used for any lawful purpose. It is not objectively reasonable for a person to have an expectation of privacy in those circumstances. So if the court...
What about the idea that, you know, he has really no other reasonably, I mean, it's really coerced kind of situation. I mean, because he has no real other means of communication with his family or friends.
I would disagree with that. First, he of course can have visits. He can also write letters with people. And the bottom line is, just because a choice is difficult does not mean that someone is coerced to make it. He is warned. He impliedly consents to the recording by using the telephone, despite that he is told that he will be recorded. A difficult choice isn't one that you're coerced to make. Every choice has consequences, and he made his choice. If the court has no further questions, I would rest on my briefs.
Thank you, Mr.
Thank you.
Moore.
You keep going, get it all over with.